Under the Securities Act of 1933, every sale of a security must be either registered or exempt from registration. Section 4 of the Securities Act exempts certain transactions from registration. In Ackerberg v. Johnson, the Eighth Circuit examined a commonly used resale exemption, Section 4A1. Norman Ackerberg bought shares of stock in Vertimag Systems Corporation from Clark Johnson, one of Vertimag's founders. Prior to selling the stock, Johnson had owned the securities for at least 4 years. Ackerberg also bought some Vertimag stock from the vice president of Piper, Jaffray, and Hopwood, a brokerage firm. Piper gave Ackerberg a private placement memorandum containing detailed information about Vertimag. Ackerberg also signed a subscription agreement in which he affirmed that he met certain substantial income requirements and understood that the Vertimag securities were unregistered and not transferable. About a year later, Ackerberg sued Johnson and Piper for violating the Securities Act of 1933 and other securities laws. Johnson moved for dismissal of the claims against him. He argued that he was entitled to an exemption from the Securities Act's registration requirements under Section 4A1 because he wasn't, as Ackerberg contended, an underwriter. The district court disagreed. It found that Johnson wasn't entitled to an exemption and granted summary judgment in favor of Ackerberg. Johnson appealed to the Eighth Circuit.